Hi everybody. We've waited till 13:01 just to give people an opportunity to join us, but we will now start off. Thank you for everybody that's joined us this lunchtime and for giving up your lunchtime to join us. We're going to be talking about raising the bar on legal and regulatory compliance, but I guess you know that's why you've joined us for this presentation. I'm absolutely delighted to be joined by Sarah from Anthony Collins, who's got some really lavishly decorated slides later on in the session. But first, we're going to wade through my less so. So again, thank you very much for everybody for joining us. We've got instructions about when we're meant to have our cameras on and our cameras not. We've put our cameras on. If we leave them on too, we'll just do the introductions and then I think we take them off. So I'll just move on to this next slide. So I'm Keith Ward. I'm an external audit partner by trade, and I also head up the RSM social housing team. And I'm delighted, as I say, to be joined by Sarah.
Good afternoon. I'm Sarah Patrice from Anthony Collins Solicitors. I'm a senior associate in the governance team there, where I've been for nearly 20 years. So I'm primarily a specialist in governance and commercial matters, but I'm covering some broader areas today for you. So any particularly tricky questions, I will gladly take back to colleagues in the office.
Great, thanks, Sarah. And I'm on duty throughout doing presentation mode now and then being official slide turner for later on in the session. Okay, so without further ado, this next slide just talking about from a housekeeping point of view, everyone is on mute throughout, but there is the functionality to submit questions using the Q&A button to the right, and also some instructions for if that doesn't show up. We're also largely to check that you've not just sort of signed up and then gone to have lunch. We've got a number of polls that we're going to be asking you which demand a very quick response time. So we'll be asking those. Just to put you at ease, none of them are during the audit part of it. They are during the legal compliance bit later on. Brilliant. Okay, so I'm going to be talking about the auditing standards, and then, as I say, Sarah's then going to talk about some of the more practical applications. So without further ado, I shall move on, and just remembering to stop video. So the reason that we are doing this presentation today and how it came about is being driven by two changes in international standards of auditing, and we realised very quickly that the clue is in the title. From RSM's point of view, we've had some invaluable discussions with Anthony Collins in terms of how this might impact on the social housing sector, leading to an article in January's edition of Social Housing magazine and then this seminar. And it's really our attempts to drive up an understanding of the audit implications of the changes, but then also how you can use this as a real opportunity to look at how you ensure compliance within your organisation within this area. And we're looking at the two standards, ISO 250, consideration of law and regulations. That's been with us quite a long time in terms of what it's saying about compliance with law and regs. What has changed is in ISO 700, which is the auditing standard that drives the audit opinion and reporting on the financial statements. And it's the combination of these two areas that we're going to be looking at. So to dive now into detail into these two standards, and I've got some very text-laden slides, but I started to paraphrase what the standards were saying to make it more punchy and appealing, but felt really it's probably, rather than diluting what the standard setters have set, it's probably best actually to go over that with you and just repeat what's in there. So the standard very much clarifies that it's the responsibility of management with the oversight of those charged with governance. So traditionally, board delegates that down to the audit and risk committee to ensure that your operations are conducted in accordance with the provisions of law and regulations, and including compliance with those provisions that determine the reported amounts and disclosures in the entity's financial statements. So there's those that have an impact on the financial statements, but it's the whole legal and regulatory framework that applies to your social housing business that we're talking about. And the ISA splits really into sort of the two main categories. It's those law and regulations that have a direct impact on the financial statement, and that's really the ones that determine Companies Act or Cooperative and Community Benefits Act, tax legislation, that and the framework that says how you've got to prepare the accounts, that says how you should be preparing and reporting in your financial statements. And we have got an absolute responsibility to obtain, as auditors, sufficient appropriate evidence of assurance to determine compliance. And we do that. We look at disclosure checklists. We look, and that very much drives into our audit. And for management and those charged with governance, there is a clear need to comply with that. And that's really not changing. What is being looked at more by the audit standard on reporting is the compliance that's fundamental to the business, non-compliance of which may impact on the financial statements. So those areas that are key to your business and the non-compliance of which could just have that impact. The auditor responsibility is limited to choosing specified audit procedures to help identify that compliance with non-laws that may then have a material impact on the financial statements. And again, your responsibility as management, as board members, is to ensure that you are driving compliance in these areas. So diving down into that in a little bit more detail, the standard then goes on to consider what if there is non-compliance, what actually is the process there. And there's a great amount of detail to say, in the standard, what happens. As we've mentioned before, the directors are responsible for the preparation of the accounts that give a true and fair view. So this is where we then look at the interrelationship with non-compliance, because if there's non-compliance with law and regulations, if that's not detected, does that mean that there might be a material misstatement in the financial statements? So that's where you can see it starting to become of interest to the auditor, because it's this element of what happens if there's been a non-compliance. And it's for the directors to ensure that the matter is appropriately reflected and or disclosed in the financial statements. So it's saying if there is a non-compliance, is it something that's significantly material to require reporting on? And certainly one of the main areas of law and regs that comes to mind at the moment, which may or may not affect, is the whole disclosure, the whole guidance around the coronavirus job retention scheme, in terms of, a lot of organisations have taken advantage of that. There's something like 174 different laws and regulations governing that came out since it started in less than 12 months. And there's going to be naturally non-compliance with that just because of the complexity. But it's then for the directors to consider, is that going to be materially significant to go in the financial statements? If there is non-compliance, then from the auditor's point of view, what we've got to do is look to see from a detection point of view, regardless of materiality, whether that non-compliance could impact in other areas. Is it willful non-compliance? Is it because of lack of understanding? So again, this is quite a challenging area. We've got to consider the integrity of management that has led to those areas of non-compliance. And then there's further guidance that says actually non-compliance is actually a matter to be determined by a court or an appropriate body. But fortunately, there's an expectation that the auditor's training to enable us to be Superman or Superwoman will enable us to have a basic understanding to recognise that some acts that we should be able to spot areas of non-compliance with laws and regulations. But the first port of call is with management. So that's what ISA 250 talks about. It's those two aspects. It's those legislation and regulations that set out how the account should be prepared. And it's then those areas of law and regulations that you run your business under, and it's looking at the potential for non-compliance with those areas. So that's fine, and that doesn't impact on the audit report that goes in the financial statements. And ISA 250 has largely been in place for a number of years. There's been a bit of a revision, but largely it's been saying that. So what is then driving this current level of activity and interest? And this is ISA 700, which is the auditing standard that talks about how auditors should communicate through the audit report. And it's one of the sections here, section A39, that talks about irregularities, including fraud, that the auditor needs to refer to. And irregularity isn't actually defined in legislation, but again, there's an immediate reference back to ISA 250, which tells us what irregularity is and what non-compliance. And one of the aspects of irregularity is non-compliance with appropriate law and regulation. So you can see how the two auditing standards come back to ISA 700 is very much putting the importance of ISA 250. And what needs to go in the auditor's report is to enable users of the financial statements to understand the significance of key law and regulations. And it's interesting the word significant is used, and that also isn't defined. So there's a bit of a question mark. Does significant equate to materiality? But actually, we think it probably means more than that, because some aspects might not have a financial equivalent, might be reputational. And it's one of the other things that the auditing standard requires is that there shouldn't be a standardised, and yes, it is a Z in the standard, or boilerplate language, because what they don't want is just to have checklists that people use to report on. So you're going to see in audit reports from 31st of December onwards, you're actually going to see reference from the auditor. Previously, it's just a passive acceptance that the accounts have been prepared in accordance with relevant auditing law and regulations. What you're now going to see is actually reference to what those significant laws and regulations are. So what the auditor has to do, and again, I think it's important to share this with you so that you'll know what your auditors are going to be asking you about. So what we have got to do is use our understanding of your industry, your regularity, what the regulator says, and then really update the understanding of those laws and regs that have a direct impact on your accounts, on your disclosures. We've got to inquire of management as to those law and regulations that might be expected, and also your accounting policies and procedures recording compliance, and then to see if there's any evidence that you have. So really, from an audit point of view, we're going to be looking at how you identify existing, new, emerging laws and regulations that impact on your business, how you make sure that those laws and regulations are properly disseminated across the operations of the business. And I think those two areas are reasonably straightforward, but it's then looking to see how do you ensure compliance? What regime have you got in place to enable you at the company secretarial or the audit committee yet how do you make sure that if you've put a policy and procedure in place, that that is actually being complied with? And obviously it will vary from specific law and regulation to each other. So what I've done is cantered through the changes in ISO 250 that talk about the laws and regulations themselves, and then show how they then link in with specifically the audit reporting and what's going to be seen in the audit report. So that's kind of like the churn through the auditing standards. This isn't just about those saying this is what's going to change in audit. It's about saying this is a great opportunity to shine a spotlight on your internal compliance procedures to see, okay, how do we know? Is that process robust enough? So in conjunction with Sarah and Peter Hubbard from Anthony Collins, we've kind of brainstormed what we think are probably those key areas that are common to the bulk of the social housing sector. And that's what Sarah is now going to talk along to. Okay, Sarah?
Thank you, Keith. And I'm going to do my best Chris Whitty impression, so I apologise in advance because Keith is retaining control over the slides, so I apologise for that immediately. But yeah, what I'm tasked to do is look through these 4 key areas that have been identified as high-risk areas under the revised standards that Keith's just talked about. We're going to highlight what the requirements are, but also share some of our experience where clients had thought they were compliant, but then sadly found out that they weren't. It's alluded to some of our experience, but the reason that we've been asked today is because of the work that Peter and Keith have been doing collectively, but also because of the huge number of housing associations that we help. We've got legal compliance checklists where clients provide us with information to enable them to assess compliance, or we carry out those reviews. We provide 6 monthly legal update reports to highlight what's changed that you need to be aware of. And we've also recently launched the Building Safety Workbook, which will assist providers to see how advanced they are in their preparations, analysing key risks, etc. So I'll come on to that a little bit. As you see, we're going to look at building safety and fire safety issues specifically. So what we're going to work through is those key risks, taking away some of the lessons learned from someone else's pain, which hopefully makes it a little bit easier for the rest of us. And we're going to focus on health and safety, including safe working conditions and other areas that are regulated by the Health and Safety Executive. We're going to look at data protection, particularly unauthorised data disclosure, where this is accidental or due to fraud or hacking, particularly in light of the new virtual world which we now find ourselves working in. We're going to look at building safety, fire safety issues around the new legislation, particularly in relation to high-risk buildings. We're going to look at the regulatory standards from the Regulator of Social Housing, which I'm going to refer to as the regulator throughout the session, and compliance with the rent standard, again, an area of high risk that's been identified and where housing associations and local authorities, so if I refer to you as providers for the purposes of this session, if that's okay, where you might find yourselves falling foul. Be warned, Keith has warned you, there's going to be some polls as we go through to gauge where you may be at in respect of each of these things. So let's have a look at each of them in turn. Keith, if you can move on for me, please. Health and safety. Many providers have got strong knowledge of their property-related compliance obligations, such as the duty to carry out annual safety checks on all gas appliances and flues, duties to conduct electrical safety inspections on all electrical installations, usually every 5 years and at change of tenancy. And Keith, if you can move on for me, please. These obligations often also feature in regulatory judgments and feature in the regulator's annual consumer regulation review. Naturally, providers boards are often therefore prioritising receiving an overview of the KPIs in relation to these. Following the Grenfell Tower tragedy and the introduction of the Fire Safety Bill and Building Safety Bill, providers are also quite rightly focusing on building and fire safety obligations, which I will come on to in a little more detail. Whilst these obligations are really important, providers should not forget your core health and safety obligations under the Health and Safety at Work Act. Our regulatory team are often find that it is these obligations which can be overlooked and where breaches arise unexpectedly with potentially significant consequences. So moving on again, as set out on the slide for you, you can see providers have got an obligation under Section 2.1 of the Health and Safety at Work Act to ensure as far as reasonably practicable the health, safety and welfare of your employees. We've copied some example headlines from the Health and Safety Executive's website onto the slide. And whilst the headlines don't all relate to providers, they do relate to operations that providers' employees could carry out. It is often the case that providers think that by having those policies, procedures and training in place that you've satisfied the duty under Section 2.1 here. Recent cases, however, handled by our regulatory team have shown that even where we've got seemingly robust policies and procedures in place, providers can find themselves being investigated and prosecuted by the Health and Safety Executive. For example, one of our clients' employees fell from a ladder, wasn't being used appropriately and wasn't properly secured. The client had the relevant policies in place, it had provided training, it had provided the working at height plan, but the incident and subsequent HSC investigations highlighted the fact that the employees weren't being sufficiently supervised to check that they were complying with that documentation and training. So 2 points to learn from that case were it's often the implementation of those policies, procedures and training that is essential. Providers must ensure that they adopt the correct safe practices on a day-to-day basis, that each level of employee is sufficiently supervised and that there are mechanisms in place to monitor and, if necessary, enforce compliance. Secondly, you may also need to recognise that health and safety offences are based on risk and not actual harm. In this case, the employee thankfully only suffered very minor injuries, but the prosecution and the sentencing process was based on the fact that when the employee fell from the ladder, they were at risk of death, even if that risk was relatively low. This means that the fines sought by the Health and Safety Executive are often much higher than you would think. Increasingly, fines are also influenced as much by the turnover of the organisation as well as the theoretical or actual consequences of the breach. The fines imposed in cases highlighted range from tens of thousands of pounds to hundreds of thousands of pounds. In the case of a housing association, for example, with a turnover of 10 million to 50 million, with an incident involving low risk of death, where it's accepted that we've got systems to address risk and they're in place but not fully implemented, the relevant guidelines suggest a starting point for a fine of £100,000. That starting point rises to £300,000, where a provider's got a turnover in excess of £50 million. Keith, if you can move on for me, please. Providers also have an obligation under Section 3.1 of the Health and Safety at Work Act to ensure health and safety of those affected by operations. The extent of this obligation is often not properly understood. The news headlines on this slide include the prosecution relating to maintenance of playground equipment, a prosecution relating to the maintenance of a platform lift in a tenant's property, prosecution relating to poorly maintained tree, and the final one in respect of a poorly secured bollard. Providers need to assess the unexpected risks, not just the expected risks that you associate with your operations. This will often mean that you have to look holistically across your operations, housing stock, workplaces, commercial premises, etc. We picked the news headlines on the slide as all of the prosecutions relate to equipment and items that many providers are likely to own, maintain or control, but also that would not necessarily be considered inherently risky. In almost all of these cases, one significant feature of the prosecution case was a failure to ensure sufficient monitoring and inspection of the equipment or property. So, for example, the fact that the wooden pole supporting the swing has rotted or that the bollard was insecure and liable to collapse hadn't been spotted or rectified. The team also often find that when a high-profile prosecution occurs, providers are more often reactive in then putting the necessary safety measures in place. For example, following the prosecution of Synergy Housing Limited, which is the second headline down on that slide, we are finding that providers now place a much higher priority on lift safety than they previously did. Providers are also rightly focused on ensuring that they have robust procedures in place to ensure compliance with resident safety, equal attention should be placed on complying with all safety-related obligations to ensure that you're not faced with any unexpected safety-related crises. Talking of unexpected crises, this is going to move us nicely onto data protection and data breaches. But before we do, you've been warned. Here's the first quick poll.
Okay, so I think it might be duplicating if I'm speaking, but you can see the answers if we have a very quick reaction to the information that's been asked there, based upon the information that you just heard. How confident are you in respect of your health and safety compliance? And if we want your immediate reaction, A, B, C, D, or E, and submit, please. And I think we should be about to be able to show the results. I'm kind of assuming that the results will pop up in that. Excellent. So nice bit of not quite sitting on the fence, but interesting. They're somewhat confident. So I think, Sarah, you can see that you've got a somewhat confident audience. I will go on mute and we'll carry on.
That's great. Thank you. And we will come back to those poll responses if we get time a little bit later or if there are questions at the end of the session. So, data protection. A data breach is where data is disclosed, lost or amended without authorisation. Organisations should, and in the main do, have processes in place to reduce the risk of a data breach event. However, as we're going to see here, internal human error can mean that those processes are bypassed. And externally, sadly, criminals are looking to capitalise on that human error, make us pay for our mistakes. So the current increase in working from home has also increased the human error element. This is due to a range of issues. People at home can feel more relaxed and more inclined to be more relaxed when they're carrying out their work. Or at the opposite end of the spectrum, dealing with and responding to the pandemic is stressful for a whole range of reasons. Stressed people often rush, make mistakes. Being at home can mean that people are supervised less closely. And let's not forget those of us who are trying to homeschool or manage the family fallouts whilst going about their work. We're going to look at the principles of good data management and review 2 cases where this has gone wrong. And more importantly, where lessons can be learned. So we can move on to the GDPR principles. While GDPR only covers personal data, and one of the breaches that we're going to discuss didn't involve personal data, its principles are ideal to follow for non-personal but important or confidential data too. So set out on the slide for you, these include lawful and transparent processing, where all the reasons for processing the data must meet a lawful basis in the GDPR, or if the data is what we call special categories, so health, religious beliefs, etc., it must meet 2 lawful bases. Processing has to be limited to the purpose that it was collected for. It has to be used only for the reason that it's being processed. It has to be kept up to date and accurate. It can only be kept as long as necessary and for the reason it's being processed and any associated reasons, such as any possible legal cases. Data has to be kept secure using technical and organisational measures, meaning it's more than just encryption, so it's about restricting access, training people, etc., and accountability. This is where the organisation is accountable for complying with the above and demonstrating that compliance. And I'm going to move on to that, onto the next slide, because this is actually where directors and boards should be aware, because it's the organisation at the highest level that's responsible for ensuring that other GDPR principles are complied with. How can you be confident that the organisation is complying with all of the above? Audit should cover more than just reading the policies and processes. It should also check that those processes are always being followed, which we've already touched upon in respect of the health and safety issues, and is a bit of a recurring theme, I'm afraid. So let's have a look at the case studies that I've mentioned for you. Moving on to the first one, we're going to look at successful fraud. And this is a real live example, sadly, but like most organisations, this provider, so HA number 1, very originally named, is targeted by cyber criminals every day and manages to catch and prevent most of those attempts. This one time, HA1 was a victim of a scam that tricked them into changing their records, specifically the bank details of a supplier. This meant that they were paying money that was due to the supplier into a criminal's bank account instead. HA1 lost close to £1 million before the error was discovered, and we're still not entirely sure how it came to light in the end. Its governance rating from the regulator was downgraded, expectedly, and they did have internal processes and controls in place which should have stopped the supplier's details being changed, but because of human error, the process wasn't followed. So on the next slide, we look at whilst the details were changed weren't personal data, so this is not a GDPR or data protection breach, it demonstrates the risk of failing to ensure that processes are followed on top of ensuring that they exist. This type of scam could also happen with personal data, such as employee bank details for payroll or bank details of a customer who was due a refund. I'm not sure if you've seen the adverts on television at the moment, seeking claimants to join the action against British Airways for their data breach, telling potential claimants that they could be due thousands of pounds in compensation. The Gdpr Principles of accuracy and security require organisations to apply those processes to ensure that the data is managed in a way to avoid this happening. The less susceptible to human error these processes are, clearly the better, which is one thing that HA1 said they're going to be focusing on reducing moving forwards, that human element of weakness in their internal controls. So if we can move on to the email error, this is where HA2 committed a data breach that involved customers' personal data back in March 2020, so March last year, when they accidentally emailed out customers' personal details in an email that was about how best to communicate with their clients during COVID. This email included an attachment in error. The attachment included personal details of over 3,500 customers, including special categories of data such as ethnicity, religion, sexual orientation. This highlights the kind of human error that is more likely to happen when people are working under pressure, in particular the pressure of dealing with the current pandemic, which is a challenge that pre-March 2020 we have never faced before. So, this slide sets out aspects of the risk management framework related to data that boards and directors should be thinking about. These aspects apply to risk management in general, of course, but as you can see, pick up on the issues that I've just highlighted about having those robust processes in place, carrying out audits not only to look at compliance but validity also, to ensure that training is provided and people understand why they need to follow the policies, procedures, etc., that the support of the management team is in place to seek to avoid stress and human error, and that we're monitoring compliance, this golden thread to ensure that the executive team know what's going on. The golden thread is also key when it comes to building safety and fire safety issues, which is where we'll move on to now, but not before where we've captured how you all feel in relation to this. So poll number 2.
So again, same question, you'll start to get familiar with these. Gut reaction, based on what you just heard, how confident are you in respect of your data protection compliance? Again, A through to E and submit, and we shall have a look at how we're doing on this one. And thanks very much for engaging with the first poll. We had responses from everyone except one person. And we're just waiting now for the information to transfer itself to the table, which you'll be able to see. There we go. Very consistent. Again, somewhat confident. Excellent. Okay, I'll mute and we'll carry on.
That is interesting. It's nice to see that people are relatively confident here where we're looking at these things. So moving swiftly on to building safety and fire safety issues. The Building Safety Bill was published in July 2020 and is the most significant change to the building regulations and wider regulatory responsibility regarding building safety in over 45 years. The full scope of the bill is obviously outside what we can cover today, in the time that we've got. So I'm going to look at a few of the headlines. The headline developments relating to key areas of risk for providers with high risk buildings, or referenced HRBs, which you'll see in there. So it's looking at the housing stock that's classified as HRB. The Welsh colleagues on the call, the Fire Safety Bill has been approved by the Senate, and they are consulting on the Building Safety Bill with some slight differences in approach. So, for those who are not in the know, HRBs are defined as buildings of 18 metres or higher, but there is the option for the Secretary of State to expand that definition to include lower residential buildings. Key elements of the bill include the establishment of a building safety regulator sitting within the HSE and the creation of a new duty holder regime. That regime is detailed and contains a substantial number of new obligations. The headline point is that it will require providers to think about procurement and contracting solutions for the construction of new build HRBs, and also for the delivery of significant works or repairs to existing HRB stock. Related to the new duty holder regime is also the requirement to maintain the golden thread of information that I've just mentioned in respect to section. The key information relating to the construction, maintenance and use of the HRB, demonstrating whether it's safe for occupation by residents. So, moving on, the definition of building safety risk within the bill makes it clear that whilst fire safety is a particular area of concern, it's not the only issue, and so providers with HRB stock need to be alive to structural issues or any other material issue that gives rise to building safety risk. The definition underpins the entire bill, and the accountable person, who is the duty holder under the new regulatory regime once the HRB is occupied, is required to assess building safety risks as to whether each HRB is safe for occupation. Where building safety risks are identified, the accountable person then has to identify how they can be mitigated and addressed. The accountable person also has an obligation to collate and maintain the golden thread of information for all existing and new build HRBs. A key point to note is that the golden thread of information needs to be a continually updated and evolving data source. It is not a case of preparing it once and then leaving it on the shelf, I'm afraid. So looking a bit more detail at the golden thread of information. The key risks associated with these obligations, particularly in respect of existing HRBs, is that undertaking an assessment of building safety risks or collating and maintaining the golden thread of information may well result in you identifying building safety risks that then need to be addressed. I am reliably informed by colleagues that it's not unusual to undertake these investigations of cladding systems or fire compartmentation and find some issues that need addressing, particularly on historic HRB stock. Any issues identified in the course of assessing the building safety risks and collating that golden thread of information will then, of course, need to be addressed. So moving on, the golden thread is intended to be a comprehensive set of data regarding the construction, maintenance and use of HRBs so that resident safety is ensured. The golden thread will need to be provided to the Building Safety Regulator in digital format, and it will need to be updated as and when the HRB has significant works undertaken or any changes in use. A key consideration for providers will be the procurement and contract arrangements for major works and substantial repair contracts, where contractors may be undertaking works that impact on the safety of the HRB, so for example, installation of fire doors or cladding systems. The information required for the golden thread has not yet been conclusively established, but it's deemed likely to include the information that's set out on this slide and the next. So moving on to that next slide. Investigations into the causes of the Grenfell fire have identified, as you know, a number of widespread building safety issues which had previously not been anticipated, and there's been a significant reconsideration of appropriate construction products and systems for HRBs. Of particular concern are ACM cladding systems, HPL cladding systems, GRP composite fire doors, and the proper use of wooden balconies. All of these have been covered by briefing notes throughout 2018 to 2020 from the Ministry of Housing, Community and Local Government, or MHCLG, and which all providers, I'm sure, are familiar with. It's also important to note that all of these products and systems were considered compliant prior to the Grenfell fire. The challenge for RP since Grenfell has been identifying systems and products which are no longer considered appropriate, addressing those building safety risks, and then pursuing claims against contractors and designers responsible for the specification and installation of the defective systems. Moving on to that next slide, which is where the Grenfell tragedy is a case in point in how what is considered an appropriate construction method and product can change rapidly, where industry methods and knowledge change. What was considered a compliant product can rapidly become non-compliant and need remediation. The position under the bill is that the parties responsible for assessing building safety risks will be clearly identified and subject to very prescriptive obligations. So, moving on. Two key considerations flow from this. Any remedial scheme addressing these defects will need to be fully documented within the golden thread, which also clearly demonstrates how maintaining the golden thread is an ongoing obligation. And secondly, where providers are addressing any of the building safety risks identified following the Grenfell fire, those will need to be remedied in such a way as will satisfy the building safety regulator that the HRBs in question are now safe for occupation. So, you know the drill. We're moving on to the next one. We're going to have the next poll, thank you.
Okay, so again, same process. Now, I noticed with the last one, whereas previously we had 1 out of 52 no answers, on the data quality one, we had 13 out of 52, which might indicate possibly less confidence. So again, how confident are you in respect of your building safety and fire safety compliance and immediate response? And then the answers will flow through once you press submit. Thank you. I feel we should have a roll of drums just before the table shows itself.
Oh, we've got some highly confidence in there.
Yes, that is top of the poll for highly confident, which is great because this is obviously a high risk area. But again, 10 people remaining quiet on this. Okay, back to you, Sarah.
Thank you. Okay, so finally, moving on to the last of the 4 key risks that we've identified, the regulatory standards, particularly the rent standard. Although some of the key points in the rent standard appear straightforward, or according to colleagues, they think they're straightforward, the devil is actually in the detail. This is the detail held on your own systems and whether this data is correct and tested, and are the detailed definitions for exceptions correctly applied. We've seen the regulator having an increased focus on this over recent years, and we do expect this will continue. Underpinning rent setting is correct data to input into the initial calculation, as well as thorough testing of that as increases and changes are applied. Emphasising the regulator's approach, we've seen the publication of the addendum to the sector risk profile in 2020 and the emphasis of good data in that. And in practice, the regulator has recruited a number of data analysts who, from our experience, are going through provider statistical data returns or local authority data returns with a very fine-tooth comb, identifying anomalies and seeking explanations from providers. So, there are 3 documents which form part of the rent standard. The government direction issued to the regulator, which sets out how the change would be implemented, a return to tolerances for general needs accommodation and reference rent caps. Most importantly for local authorities, it was the direction which brought local authority rents into the regulator's orbit. The policy statement of rents for social housing, this sets out the real details of the requirements for rent setting and reviews, both for social and affordable rents, and the detailed definition for various exceptions. And the Rent Standard 2020, which itself is actually quite brief because of the cross-reference to the policy statement. We're not going to go into the detail of that today because, frankly, we haven't got time, but I am going to look at two areas where we've seen the regulator take action. These are examples that have been published by the regulator. Okay, so the first one we're going to look at is specialist supported housing and the use of exceptions and the need to look at the detail of the definition. Specialist supported housing is a type of accommodation that was first introduced in the social housing rent regulations in 2016, pursuant to the Welfare Reform Act. This definition has mainly followed through to the new rent standard, save that the reference to negligible public assistance has now been added. The key here is that all 5 elements of the definition, so over this and the next slide, have to be satisfied in order for the exception to apply, and it has to be considered on a property by property basis. The element of the definition that has meant only a few properties genuinely meet this definition is the second element, a high level of support which approximates to a care home. Some providers have had regulatory downgrades because they haven't been able to show that this definition has been met or that it hadn't been considered in the first instance. The board needs to be satisfied that this definition has been worked through on each property that a provider is seeking to rely on it for. This includes understanding the arrangements that are in place with the local authority or the health service and the level of care provided and the needs of residents. So those final 2 elements on the next slide are set out for completeness for you. And for those of you who are Welsh registered social landlords, there is a different regulatory framework with regards to rent setting and rent review. So the specifics in terms of the guidance and definitions don't apply to you, but there are some similarities. However, the principles arising from the 2 examples are relevant. The importance of good data underpinning rent calculations, acknowledging that you have a little more flexibility in this regard, and checking the detail of the definitions for exceptions. The next and final example from me is about affordable rents. And the first thing to say is that affordable rent has a very specific definition and is only in those circumstances that properties should be let affordable rent. Affordable rent housing means accommodation that is provided by a registered provider pursuant to a housing supply delivery agreement between the provider and now Homes England or the Greater London Authority, and the accommodation is permitted by the agreement to be let at affordable rent, or it's provided by a provider under an agreement between the local authority and the Secretary of State. Again, the accommodation permitted by the agreement to be let at an affordable rent, or it's provided by the local authority and Secretary of State, Homes England, or the GLA has agreed that it's appropriate for the accommodation to be let at an affordable rent. The policy statement, whilst noting that providers are not subject to the local housing allowance, makes the point that providers should have regard to local market conditions, including the relevant LHA, the local housing allowance, when setting those affordable rents. The statement also, like the rent reduction legislation, makes clear the floor of an affordable rent is the formula rent. This slide sets out the key aspects of the rent standard in respect of rent setting for affordable rents and reviews. And moving on to the next slide also, it's the fact that the service charges are included within the 80% rent figure, subject to that not being less than the formula rent, and that the CPI +1 increase applies to the total amount, i.e. including the service charges, and this has caught some providers out. We've seen this particularly in the case of providers who have chosen to operate a variable service charge under their affordable rent tenancies, rather than our recommended approach of one rent figure, so effectively a fixed service charge mechanism. And the last one, you've almost made it.
Okay, so again, you know the process now. Our final poll, how confident are you in respect of your rent standard? And again, highly confident through to highly unconfident, and submit, and then we'll be able to see, again, hopefully we'll have 52 out of 52 respondents. That would be great, but we'll see how we do. Okay, and the answer table will now be automatically preparing with this wonderful technology. And then time for the roll of drums. Well, this is definitely, absolutely the top result in terms of highly confident and somewhat confident, but still 10 no answers. So back to you for parting comments, Sarah.
Yeah, I think it's really interesting and Keith, again, input in terms of your audit perspective, but it's quite reassuring, and hopefully people have gained assurance on the call and on today's session about the level of confidence that people already have in addressing these issues, which of course hopefully in turn will give you some assurance, Keith, when you're looking at these kind of key risks with them. Equally with the fire and building safety element also. It's still a bill at the moment. We're not 100% sure. So the fact that people are prepared and are highly or somewhat confident about their compliance there, that's really reassuring for them. I'm not sure if anybody wants to, when we go into the Q&A session, unmute and give any rationale as to why they are particularly confident or not sure or unsure in respect of any of those key things that we've touched upon.
Yes, I think we can both talk at the same time without it echoing. So that completes the presentation part of the seminar. So what we've tried to do is set out, again, those 4 areas that Sarah's talked through were, that hasn't changed apart from as emerging legislation. What has changed is its linkage with the auditor having to specify those areas, and we think these probably are the key areas that will have to be reported on in terms of risk of non-compliance in the audit report. And it was good looking through. Certainly somewhat confident came top in all of the polls apart from this last one, highly confident, which is great. We're about to move on to questions and answers, but no presentation at the moment is complete without an unashamed plug for RSM's 14th annual social housing sector survey. You must have had several invitations to complete this. Numbers are looking really, really great. It's our 14th year. So obviously I was a very young man when we started doing this survey, but it would be great if you haven't filled this in, if you can do, really, really appreciate. And this helps us to form our thoughts on what's happening in the sector. So we have got a few minutes now for questions and answers. I think, Sarah, I think we're allowed to go back on video now. So
indeed. I'm reliably informed, apologies, that people can't unmute. So if anybody's got questions, can you please put them in the Q&A boxes and we'll happily pick them up in there. Resounding silence means I think if we get nothing in there that everybody's more than happy, and we've got away lightly, Keith.
We have indeed, but if we just hang on in case people have got any questions or anything like that. But hopefully you've found that a useful linkage. You'll certainly know when your auditors, if of course it's not us, when your external auditors prepare their audit plan to take to audit committee and they refer to new ISA law and regulations, you'll know what that's referring to. Oh, fantastic. There's a question coming in there. So from Paul, we've been asked, when do we see the new building safety regulator being live and operating? I don't know, Sarah, if that's something that you're privy to, that information.
I didn't ask, and my understanding is it's not too far away, but I haven't got a specific date for you. I will take that away and get the answer to that for you. I don't have, I'm not sure if there is a specific date when that's due live, but I will find that out and we'll share that.
Brilliant. Is that going to unleash a crescendo of questions now then that we've got those?
We've got another one. The rent standards do form part of the consumer standards, but it's the rent standard that we've focused on specifically today.
So again, what we're not saying is this is all the relevant law and regulations for social housing that is significant. What we've tried to do, I mean, we could have gone into less detail and covered sort of 20 or so laws and regulations. But what we tried to do was to pick the big four and then drive into those. And again, it's probably asking what you need to be doing to get yourself up from largely confident to highly confident, because ultimately for either management or those charged with governance, that's the level that you need to be operating at. Another question. Gosh, I've not heard anything about the funding of the building regulator. Again, so I think that might be one we'll have to add to the list. But if they are going to be self-financing, then that means they are going to be being charged out to housing associations and local authorities. I think it wouldn't be a surprise if that came out, because again, I don't think the government's got any money left.
Yeah, I think that's fair.
So time for one more question. If there's someone else got a question out there. If not, I'll start to be wrapping up. And firstly, that's to thank everybody for joining us. And it was great to see that we didn't lose anybody during the presentation, Sarah. Everybody stayed with us. Everyone was responding to the polls. Thank you very much. Hopefully, everyone that's been on the presentation has found it's useful. If nothing else, to give you some questions to go back with. Really, really grateful to Sarah and to Anthony Collins for joining us on this presentation. And certainly, as I say, we don't want this to be seen as yet another external audit obligation. We want this very much to be focusing attention on the opportunity to say, right, let's have a bit of a shake of what we do within our organisation. So that's all from me, Sarah.
Yeah, thank you. Thanks for inviting us today. If there are any questions about that you didn't want to share publicly and you want us to answer those on a one-to-one basis, I'm happy to be contacted. And if it's not my particular area of expertise, to link you in with colleagues, or if anybody wants any information about the products and support that we can provide you with, again, just get in touch with me, or if you've got one of your usual Anthony Collins colleague.
Actually, Sarah, there's some nice comments coming in, some thanks. So I think we might leave this open a little bit longer to watch the positive comments coming in. So no, but brilliant. It's been moved on. So thank you very much for your time and attention, and have a nice rest of the day. I think, yes, we will be sending the slides around to delegates, definitely, and probably a link to the State of the Sector survey. Okay, thanks very much. So I think we'll end it at that point. Okay, thank you.
Thanks all. Have a lovely day. Bye.